Hello friends, in the series on the income tax cases, today we will discuss the importance of reasons in any quasi-judicial, judicial or any administrative order. Since in this series we discuss only the income tax cases, and in the income tax cases, now all the litigation rooms around Section 147 read with Section 148. So this case is also on a writ petition filed by the Assessee against the notice issued against the Assessee under Section 148 without reasons. So what is the fate of these type of notices has been decided by the Gujarat High Court in the case of BHARATKUMAR NIHALCHAND Shah versus Income Tax Officer, and this case has been reported in 463 ITR at page number 94, and the date of the judgment is 7th March 2023. In the present case, the notice under Section 148 was issued to the Assessee by giving the reasons that the Assessee has created profit/loss of rupees 74.62 lakh by both buying and selling of trades in the Bombay Stock Exchange. When the Assessee received this notice and the reasons, it was the submission of the Assessee before the High Court by filing a writ petition that the reasons are cryptic in nature, and even the Assessee is not in a position to defend his case by these type of reasons. The reasons given by the revenue only suggest that the Assessee has traded in the business or has done some investment through the Bombay Stock Exchange, nothing more than that. In Section 148, read with Section 147 proceedings, the whole proceeding hinges on the reasons recorded by the assessing officer. When the reasons are not clear or when the reasons are cryptic in nature, then the right of filing the objections by the Assessee is only an eyewash. And the Gujarat High Court quashed the notice under Section 148 in the present case by saying that in the present case, the reasons given by the revenue are vague and the Assessee cannot defend this notice by filing its objections. With the liberty to the department that the department can issue the notice under Section 148 again if the time limit permits. While dispensing with the writ petition, the Gujarat High Court laid down the importance of giving the reasons by quoting the Supreme Court judgment. The court said that reasons in administrative, quasi-judicial and judicial orders is an essential feature for the dispensation of the justice. The court said that the reasons are of paramount importance and the reasons are necessary for the basic rule of law. The court further said that the reasons are mandatory requirement of the procedural law and the reasons should be cogent, clear and succinct. The court said that only by giving the reasons, the judicial accountability can be established. If there are reasons, only then it can be said that the person who is deciding the issue is faithful to the doctrine of precedents. The court said that the reason should not be only the rubber-stamped reasons, and the reasons are very much necessary for the judicial review. At the end, the court said that in Section 147 proceedings, the whole proceedings hinges on the reasons recorded by the assessing officer, and if the reasons are not given to the assessee, then the right of filing of the objections before the assessing officer is only an eyewash. So in the nutshell, the reasons given in the present case were very vague because it were only suggesting that the assessee has incurred some profit or loss in the share market. Nothing more than that. It was not suggesting that some income has escaped assessment. So, the Honorable Gujarat High Court quashed the notice under section 148. At the end of this video, once again I am repeating the name of the case. The name of the case is BHARATKUMAR NIHALCHAND Shah versus Income Tax Officer, and this case has been reported in 463 ITR at page number 94, and the date of the judgment is 7th March 2023. Thank you, friends.